welcome to this, our 27th Annual International Conference, the world's longest-running independent privacy conference. We have people here from 21 countries, and our 48 speakers have red dots on their badges, and they're from 13 countries. Now, this is our international report, and with a sample outside. Now, in its 28th year of publication, and we also have a red UK edition as well, and that's in its 14th year. Both are published 6 times a year and available in paper and electronic formats. One of our correspondents is former president of Spain's Data Protection Authority, Professor Artemi Lombarte, who wrote this front-page story in the June, that's the current edition, and it's available as a sample here for you. This is a survey we published about a year ago, which showed the profile of 99 countries around the world with national privacy laws. We will be updating that, but since then we've had 2 new national laws that we know about, Kazakhstan and South Africa. We don't have a speaker from Kazakhstan, but we do have a speaker from South Africa, Pamela Stein, who's here, and we'll be hearing from her at midday today. And we also survey the countries with bills. This is the UK edition, the red one, and the front page story there is sort of reflects the themes of the presentation tomorrow by the UK Information Commissioner, Christopher Graham, and the Minister of State for Justice, Simon Hughes. And did you know that next week is the 30th birthday of the original Data Protection Act for the UK, 1984? And also, it's the 40th anniversary of the United States Privacy Act, 74. And tomorrow, it's the 40th anniversary of Sweden's Data Act, the first national law, data protection law, which entered into force 40 years ago tomorrow. This is a flyer which is in your bag and tells you that subscription includes access to back issues back to 1998. You get email updates, helpline inquiry service, an online search function, events documentation, and a 27-year country subject and company index. This shows some of the places we've held privacy officer network roundtables. So in many countries over more than 10 years, where we've had meetings in 16 countries. They bring together companies and data protection authorities actually around a table, not necessarily a round table, it's a rectangular table often, but never mind, and both sides appreciate a win-win opportunity to learn about practical problems arising from the way that laws are framed or interpreted. Now onto the themes of our conference today. It's clear that the new horizons we're talking about for personal data also carry new risks. Increasing amounts of personal data mean more matching risks to individuals. Organizations use technology in new ways to exploit personal data. Responsible organizations also use quality management principles, as we'll see in a session later today from Allianz Asset Management. And we have other company examples and case studies throughout the conference. Obviously, legal and procedural safeguards often lag behind the technology. But the privacy by design principle declares that it's better to build in privacy protection from the start rather than bolt it on. Now, some sessions today deal with some of the themes mentioned in points 1 and 2 there. Profiling, the boundaries. We noticed over the recent years, boundaries of what is acceptable to consumers keep shifting as consumers embrace new benefits. So the law can't be too static, has to recognize things do change. As with geolocation devices, once thought of being terrible, but we also have to reflect, when does following someone or liking someone become stalking? Where's the balancing point there? And the answer is when you don't want it. You don't want to be followed if you don't want it. But many people don't know how to adjust their settings. As for mobile data, we have sessions on that subject today and Wednesday. Apps are developed everywhere by organizations large and small and individuals. And the question is, should society tolerate different standards for major companies and small developers? The data protection authorities are working on this subject via the Global Privacy Enforcement Network, the organisation of 40 data protection authorities, including some represented here. In May, they conduct a sweep of mobile apps in their jurisdictions, and there are initiatives sort of popping up all over the place. Just early this month, the German land or state authorities approved a new set of guidelines. The question is how to make the guidelines enforceable with such a huge number of people developing apps. As for wearable tech, trainers may measure your running statistics, but data sharing with whom A breach could reveal your running route to people, and maybe you don't want them to know about it, and the information could identify when you're not at home. So there are various risks there. As the Internet of Things, to what extent is this becoming creepy is the question. How to apply data protection laws to new phenomena. For example, smart energy apps. Earlier this year, in January, Google bought Nest Labs for $3.2 billion, and it's an indicator of data commercialization everywhere. A commentator in the Climate Group on its website commented on this acquisition, quote, Nest smart thermostats are designed to save energy by working out whether or not a building is occupied, using clever sensors and learning from users' behavior, end of quote. And so we recognize there's a risk that smart meters being rolled out to homes across the European Union as a matter of policy could make people feel that they're being watched by Big Brother, as in George Orwell's 1984. Now, number 6 is beyond perhaps George Orwell's imagination. News gathering and data collection by drones are becoming more often used in the United States, perhaps less so in Europe, but no one expects to have their lives turn into a game of drones. Now, and number 7, EU data protection regulation. Running to, of course, the regulation is sort of trying to catch up and keep up with data services, which are expanding all the time. One law in the European Economic Area is attractive for business, but there is a tension between the vision for a single European market and settling on a compromise text which is too restrictive. On the other hand, leaving everything to the concept of accountability does not accord with the fundamental rights charter approach in the European Union. Everything depends on the finale, how it will work out in the end. More on this subject tomorrow. Well, new laws are coming all the time. As I mentioned, South Africa had a new law which was enacted in November last year, and a few weeks ago there was a new internet regulation in Brazil. And Pablo Palazzi, I was talking to him last night, our speaker from Argentina, who follows privacy laws across the whole of Latin America, said it's not quite what it seems, but you'll have to go to his Latin America session to find out what that's all about. Now, point 9, the European Court of Justice right to be forgotten decision in May this year. That came on too late to be fitted into this programme, but it did sort of hit the news in a very big way. And I did notice that there was a headline story in the Financial Times the day after. It's rare to get, or unique to have a data protection story as the front page story. EU privacy blow to US internet companies, it says here in the Financial Times. So our subject is certainly being recognised more widely than in the olden days. Now, Google, has to be said, has made a quick follow-up to its promise, follow-up to that decision. It made a promise when Mexico had hosted the Data Protection Authority's conference in Mexico in October 2011. It said, the company said that Peter Fleischer, on behalf of the company, said that it would follow the decision, the ECJ's decision, whatever it was, and certainly they set up a system in Europe to accommodate people who wanted to have their right to be forgotten. And as of 11th of June, the figure is that 52,000 people did exercise their right to be forgotten in the sense of cutting their links from the search engine to the stories. So Google's giving it a try, but applying that decision just within Europe. We don't know how other companies are responding to this, like Microsoft and Yahoo, but we'll wait and see. Now, what it comes to is privacy a burden or a competitive advantage. 2 examples. EU-based cloud providers, such as Deutsche Telekom, have considered advantage of gained business from clients unhappy with the surveillance of US-based cloud providers by US government agencies. And Apple sort of was riding on this wagon as well, announced earlier this month that all future versions of the company operating systems will include DuckDuckGo, which is a bit strange name, but the first privacy-focused search engine, they say, the built-in option for the Apple Safari browser. There is a similar company in the Netherlands called Ixquit. Now, is privacy a burden or competitive advantage? Probably most organisations see privacy as both a regulatory burden and a competitive advantage, but when managed carefully and given appropriate resources of time and budget, it can be a benefit. So the question is, you recognise this as the sort of symbol from our conference. This is an astronomical clock, which is just across in the courtyard, the old part of the college. I'll zoom in on the conference figures on there. The question is our attitude, should it be, here comes the sun, as reflected there, or do you feel for some reasons there is a shadow hanging over you? So that's the question. So in short, this conference has the role of exploring many new horizons in today's environment and assessing new risks. We'll cover all the points of the compass there, and, or rather the sundial, we'll call it a sundial maybe. So that's one of the images. To honour Greece's presidency of the European Union, the role of data protection authorities reflect Greek mythology, modern-day centaurs or one of those, with the head of a man and the body of a horse charging into battle to protect individuals' privacy rights. That is, protecting rights for those who don't have the strength to stand up for themselves. Now, that's also another of the images. Dissatisfied data controllers or individuals can appeal to the courts, which weigh the merits of their cases using the scales of justice. Both on the left and on the right is the European Court of Justice logo, as you see, closely matching the picture on the astronomical clock. Lobbyists have rich resources, so appear to have the strength of lions. But as the European Union Data Protection Regulation reflects the EU's Fundamental Rights Charter commitment, some form of collective action may be recognised in the EU regulation, and collective action, like the crab, could give data controllers a nasty bite. And there's also a nasty bite of negative publicity arising from a data breach, which can be whipped into a frenzy in moments via social media. Now, what about the goat? Specialist lawyers are sure-footed, like goats, in finding their way through legal complexities to make their case for their clients. We have many lawyers here over the course of 3 days, and you can talk to them about that. Now, in short, we are the final one. We are collectively at this conference working together to discuss the issues in a temperate and cooperative, actually rather sunny today, climate, to find optimum solutions to privacy challenges. So privacy, in short, privacy challenges present us with both risks and at the same time opportunities for business now and on the horizon.